Prophet Ron Dwayne Whitfield recording on Wednesday, October 3rd, 2018. Whitfield Ron Dwayne versus Texas State of First Court of Appeals. If there is no judgment, in this case, I did 19 and a half years in prison unlawfully in violation of the 14th Amendment protection to not be denied of my freedom, liberty, without due process of law. We go all the way to the bottom. Okay. Notice of appeal filed June 5th, 1992. Date of sentencing criminal case. 1992. Submission. April 13, 1993. Order entered. Submission. Opinion issued. Affirmed. Opinion affirmed. Motion for rehearing not filed. No judgment. No judgment. An opinion is not a judgment. It tells you the reasons, the rationale followed, leading to the judgment. There's the mandate. I served 19 and a half years in prison, in the Texas prison system, in absence of a judgment of this court. It's a problem, world. It's going to be a problem. It's going to be a major problem. Major problem. In the Bible, it is recorded, entered in the minutes of John 14, verses 16 through 17 and 26. And in John chapter 15, verse 26. And finally in John chapter 16, verses 7 to 15. There's no judgment. And I mailed all those letters from prison from 2004. One back is 2004, all these letters announcing that I was God's last prophet and that there was no judgment in this case. Here's the action this court took. Here's the action the court took since I've been out. So just so President Trump, the United States Attorney, and the FBI Director be known on notice. The appellant was convicted of burglary of a building with intent to commit theft, and after being enhanced by 2 prior felony convictions, was sentenced to 35 years in prison on June 5th, 1992. A mandate will not be issued in absence of a judgment. You think Justice Higley does not know this? You think I trust Justice Higley with sitting on the court with my child? Life is at stake. Mine is at stake. Now, so she wants to play this game, saying that, uses the word apparently, claims that there was no proper rendition of judgment because, among other reasons, the criminal complaint was apparently time-stamped when the trial clerk's office was closed. The copy of the opinion he attached to his motions, apparently received from the clerk of this court, was not physically signed by Justice O'Connor. And because the copies of the opinion and mandate, which apparently received from the trial clerk, did not contain the same file marks as those from the clerk of this court. On June 24, 2009, while I was still incarcerated, we had previously dismissed, for lack of jurisdiction, appellant's similar pro se motion to recall our 1994 mandate as void for failure of this court to render its judgment. Here's what you call a transitional transition. What is it called? Well, I'm not thinking, but it's transitional when you see in any event after our mandate issued on March 9, 1994, our plenary power expired, and we lack jurisdiction to vacate or modify our judgment. Now, this justice has been to law school. She's been to law school. She's apparently has an education from elementary to junior high, middle school, to high school, college, law school, has passed bar exams and so forth. In any event, does not address that this court has no jurisdiction at all. Not because jurisdiction, well, look, you know how I must be feeling if you know it. Okay, here's the thing. I got an audio recording from 2015, Justice Higley, from the FBI attorney, and I'm going to put it over on the internet. And he's saying that if there be no judgment in this court, and I brought this to this court's attention, if he used the word if, there be no judgment, and you did not correct this problem, you commit a crime, Justice Higley. You commit a crime. He said, and I'm going to let the world hear that, if this FBI attorney in Houston, a civil rights attorney, stating, dealing with cases under Title 18 United States Code Section 242. So if agents of the FBI have questions, they go to these attorneys for advice or whatever they do like that. So they put him on the phone to talk to me. Okay, so This is what he's saying. So where was I at? In any event, after our mandate issued on March 9, 1994, our plenary power expired and we lack jurisdiction to vacate or modify our judgment. Vacate, change. You cannot vacate or modify that which does not exist. Now, we also got you, Mr. Chris Prime, on YouTube admitting, too, that there is no judgment. So, Mr. Chris Prime, I'm going to inform you, requested you, bring this to the attention of the court, because you see, this is Justice Higley acting individually and not acting for the court. She has no authority to rule on this motion to recall mandate because she is not the court. She is merely an officer of the court and a member of the court, and it takes a panel or in-bank to rule. And let's see if this instrument purports to have been, it doesn't show that it's been even filed in the record of the case. It doesn't even show to have been filed. Look at it, you see no file mark. And just as Judge Marvin O.T. would point that out in any opinion that he would be authoring, it does not bear neither a seal nor a file mark of the court. Let's see what it shows at the top. Where's the seal? It will not have a seal unless it's issued out. That's why it will have a file mark. The file mark makes it official as a record of the court. That's not a signature. Now, when we look at the laws today, let me join church, so to speak. Join church, so to speak. Close all this out. Let's see. There's no file mark here, y'all. There's no file mark. This is issued from the First Court of Appeals to the various places where it goes, such as the Austin, Texas, the Harris County District Clerk's Office. We'll just go right to see if this opinion has any validity to it. Any validity. This justice shouldn't have been in the case because it's not a signature. It's not a signature. There's no proof that Justice O'Connor even knew of this opinion. It's not filed. And even if it were, it's just an opinion. It does not order anything. It does not put the case out of court. Will overrule point of error 2 and affirm the judgment. Okay, here's what's going on, people. I'm just doing this for the FBI, so if things, truth gonna come. We're gonna see what's going on in the history of the United States, the future. I'll keep this video at 20 minutes. Okay, I will attach that to it as well. So render to justice see if that'll give me where I'm going. I hope that's not going to give me where I want to go, so I'm misspelling it. Okay, I'm misspelling it. Supreme Court of Texas. Is he out there? Okay, he's not out there. Enter. Okay, here it is. I need to print this. Take it to the FBI. I'm tired of suffering. It's foolishness. So once you save it, then I want to print it. Six sheets. All right. Okay, here we go. In 1975, the Honorable Robert W. Calvert, retired Chief Justice of the Supreme Court of Texas, authored an article about Texas Appellate Court judgment. Robert W. Calvert, appellate court judgments are strange things happen on the way to judgment. Let me pause. Okay, this is the same thing. Let me start over. Okay, it's the same thing. I want to go to page 175. Just get right to the point. This is where the crime is being established. Here, this is former Chief Justice Calvert. Appellate courts render judgment whenever they decide cases on appeal. The reason for whatever judgment an appellate court renders are stated in an opinion, which the court must hand down. An appellate court commonly states what its judgment is at the end of its opinion, though it is not required to do so. And sometimes it also recites its judgment in the opening paragraph or section of its opinion. These are the old rules in effect or former rules in effect when the lawsuit I took there was in effect. Texas Rules of Appellate Procedure 43.2 enumerates the types of judgments that a court of appeals may render. Affirm the trial court's judgment in whole or in part. B. Modify the trial court's judgment and affirm as modified. C. Reverse the trial court's judgment in whole or in part and render the judgment. D. Reverse the trial court's judgment and remand the case for further proceedings. E. Vacate the trial court's judgment and dismiss the case, or F. Dismiss the appeal. Okay? Here, the trial court's judgment, which none exists, but if it had existed, it's not final. Based on the principles and rules discussed above, an appellate court is required to perform 4 distinct functions. 1, to decide issues and causes. 2, to write opinions which reflect the reasons for the court's decision. 3, to render judgment which must act upon lower court's judgment. And 4, to dispose of the causes. Straying from concepts. Recent appellate court opinions illustrate how some courts have failed to adhere to the principles discussed above. I end this video.